Well, thank you, Mr. Chairman, for not only for holding this hearing, but for including two of my pieces of legislation in it. I deeply appreciate that, and I also want to thank and express my appreciation to Chairman Small for his willingness to join us at today's hearing. The Chairman and I have been working on this legislation for the past 3 Congresses now, and we hope this is the last time that this committee will need to hear from us on this issue. S-2040, the Blackfoot River Land Settlement Act, embodies the terms of a negotiated settlement between the Shoshone-Bannock tribes, non-Indian litigants, and the state of Idaho relating to the ownership of land and water rights. In an 1867 executive order, President Andrew Johnson established the boundaries of the Fort Hall Indian Reservation for the Shoshone-Bannock tribes in southeastern Idaho, including the reservation's northern border tracing the then location of the Blackfoot River. The resulting property holdings have tribal-owned lands. In 1964, the U.S. Army Corps of Engineers, on behalf of the Blackfoot River Flood Control District number 7, completed a flood control project that resulted in channel realignment of the Blackfoot River. And the resulting property holdings that have come from that have tribal-owned lands north of the new river course and non-tribal lands south of the new river course, severing several contiguous land holding and creating situations and creating ownership disputes. The BLM cadastral surveys dating to 1999 show 44 tribal and non-Indian parcels are affected, covering 13.49 linear miles and approximately 68 acres, 37 acres to non-Indians and 31 acres to tribal members. S-2040 would extinguish all claims and all past, present, and future right, title, and interest in and to tribal land and the non-Indian land. Enactment of this settlement is in the benefit of all of the affected stakeholders, as the tribes and the United States are expected to pursue trespass actions against non-Indian landowners and condemnation of their lands. Mr. Chairman, absent action on the legislation, an outcome no one wants, is going to be contested legal proceedings. In order to move S-2040 through the committee and the full Senate, we removed the authorization for appropriations. All affected parties, including the tribes, North Bank non-Indian land owners, and the Blackfoot River Flood Control District, have agreed to forego congressionally directed compensation in lieu of advancing this bill. Instead, the bill would take the lands located on the north side of the Blackfoot River into trust. The negotiated settlement would then transfer the southern tribal land to the Flood Control District, which would in turn compensate the non-Indian land owners through the sale of those lands. As you can see, the tribes would no longer be compensated monetarily under S-2040, but I'm currently, Mr. Chairman, exploring several alternatives separate from this bill to keep the tribes whole. Because we've removed the score, I expect Congress to act swiftly on the legislation now that is before us. And thank you, Mr. Chairman. And then finally, just briefly on the second piece of legislation, I'm pleased that the committee will also hear testimony regarding S-2041, which would repeal an outdated and archaic congressional authorization. On May 31, 1918, Congress authorized the U.S. Department of Interior to reserve a 120-acre tract of land within the Fort Hall Reservation for the establishment of a local town site. Although we aren't entirely sure on the congressional intent, we think this was either to provide unneeded federal oversight within the reservation or to help the tribes market their agriculture in a central location, perhaps both. Regardless, this town site never came to fruition. In 1966, 48 years later, the Interior Department restored 4 of the acres, and the tribes are now seeking restitution of the remaining 111 acres. Bingham County, which currently owns this land, fully supports this bill. Bingham County and the tribes currently operate under a memorandum of agreement in which the county does not assess property taxes and defers to the tribes on regulatory authority and zoning issues occurring on the tract. In turn, the tribes provide all essential government services. Although this cooperative agreement works well, Bingham County would like to officially absolve itself from liability concerns stemming from its ownership, and the tribes would like to purchase the property at fair market value. It's my hope that this important legislation will be reported favorably out of committee also during our next business meeting. And again, Mr. Chairman, I thank you for your action on these 2 important pieces of legislation to us.